Mr. Hardin?
Thank you, Your Honor. Now, Mr. Penley, by the way, as we move into the things that happened in the month of September of 2020, did you yourself ever produce any real extensive notes as to what you remember about the events that occurred during that time? Oh, well, not only turn it on, but lean up, okay?
Yes, the answer is yes. I did write notes, and I produced a 7-page memo.
And have you asked, and therefore have with you, if you could have those notes available to you as we talk about the matters that go forward?
Yes, sir, I have them right here.
All right. Now, what I'm going to instruct you and suggest to you is, if at any time you think you need to refer them to refresh your memory, you can refer to them, but then testify from what you believe at the time. If your notes tell you something that you can't remember exactly, certainly want to be telling the judge and the other side that, okay?
Yes, sir.
Now, let's go forward. I believe you were at the stage of talking in terms of trying to assure the Attorney General you were willing to continue to investigate, correct?
Yes.
And what was your hope that if you continued to investigate, what was your hope that would accomplish?
My hope was I could dissuade him from believing that this investigation had any merit and should be continued.
All right. Now, at that time, were you personally upset with the Attorney General?
No, sir.
What was your mindset as to what you wanted to try to do for him?
I thought he was misguided. I thought he was biased against law enforcement to his detriment. I thought he was too aligned with Nate Paul, whether through friendship or as time went on, I began to believe other things.
I don't want to as time went on, okay? So having said that, we'll get to that. My point is when we're in the narrative. At the end of the day, when you reached out to the Attorney General, can you tell me, after you found out about the fact that he wanted to appoint outside counsel, did you, if we get to the middle of August, at that time, were you aware as who he had decided that he wanted to retain?
Not in the middle of August, but in the middle of September, yes.
All right. Approximately when did you become aware of whom he wanted to do the investigation?
That would have been on the September 14th meeting with Jeff Mateer.
All right. And then once you found out who it was, what was that he wanted to hire, what was the next thing you did in your involvement?
Well, I found that out on the 14th. On the 14th, I also spoke to Michael Wynn and kept trying to get documents. Then the next day, the 15th, I emailed Michael Wynn and left him a voicemail, no response. On the 16th, the Attorney General called me to his office.
All right. Now, when he called you to the office, were you still, had you done for 2 straight days been trying to get documents from Michael Wynn?
Yes.
And did you personally talk to Michael Wynn either of those 2 occasions?
I spoke to him on the phone for 5 minutes on the 14th.
What did you tell him?
I told him I needed the rest of their documents. I said, I've realized I don't think I have everything you got from the judge. Would you please give me the documents? And then he promised to get back to me. He never did.
So the next thing you heard about it was on the 16th?
From the Attorney General, the next conversation was the 16th.
And where did you have this conversation? Do you recall whether it was in person or the phone?
It was in person in his office.
And how did it come about? I mean, how was it? Did he call you? You call him? What?
He called me.
All right. When he called you, what did he say?
He said, come to my office. I want to talk to you.
When you did come to his office, what happened?
He said, what are these documents you're asking Michael Wynn and Nate Paul for? I want you to write down a list of the documents on a piece of paper.
Wait, stop a second. How would he know that you were still asking Michael Wynn for documents?
Well, I only know of one way, and that would be Nate Paul was calling.
Calls for speculation.
Well, let me ask you this. Do you know of,
Dane.
excuse me, I'm sorry, Judge. Do you know of any way else that was part of your conversation on the 16th, or really, what was it? Was it the 16th with Michael Wynn?
My conversation with Wynn prior to that was the 14th.
All right. Do you know of anybody else besides you and Michael Wynn that was involved in your conversation asking him for additional documents?
The only other party would be Nate Paul, because he told me he was going to meet with
Objection.
Nate Paul.
Hearsay.
All right. So, other than Michael Wynn...
Mr. Hardin, hold on.
Excuse me.
Hold on. The objection was hearsay as to what Mr. Nate Paul told Mike Wynn.
I sustained it.
Thank you.
Sorry. I think we were three talking over each other.
Thank you. Thank you very much, Your Honor. Now, let me ask you this. When the Attorney General asked you to write down the names, did he tell you, and the documents, was it the documents he asked you to write down?
Yes.
Did he, go ahead with the rest of that conversation.
He asked me to write down the documents. He asked me for Michael Wynn's phone number. Then the Attorney General told me that they weren't likely to give me any more documents because they didn't trust me. They didn't like the way the August 12th meeting had gone. They felt I was too aligned with Director David Maxwell. And then he said, I'll try to get the documents for you.
Well, have you ever experienced a supervisor telling you that since the person who's asking you to do the investigation doesn't trust you, he wants you to get out of it, and he'll try another, and then he'll go get the documents?
Objection. Leading.
I believe.
Sustained.
Let me ask you this. Have you ever had an experience like that?
No, sir, never before.
Well, did he say why he was going to go get the documents instead of you?
He did not say.
Did he offer any support for you in their allegation that they didn't trust you?
No, and in fact, starting on August 12th, he had not supported me.
So now you've got your attorney generals against you on this issue,
Yes.
and you're still, what was your policy or procedure as you were advancing, trying to still continue to find out if you could head off the special, not the special, but head off the outside counsel?
Well, number one, I was keeping Jeff Mateer informed of everything that was going on. I was sharing my views with him. He was my immediate supervisor. And so I frequently talked to Jeff in person or on the phone and updated him on everything I was thinking and doing.
All right. So were you effectively taken out of the Nate Paul investigation after the call with the 14th?
Yes. Later, I realized the Attorney General had cut me completely out of the loop.
All right. But even at the time he did, had you ever indicated in any way that you were not willing to continue to look into the matter if they would provide you the documents they claim to have?
Objection. Leading.
That is not leading.
No, sir.
Overruled.
Pardon me?
No, I never told the Attorney General I would refuse to investigate if they would cooperate.
All right. Had you ever experienced before anything concerning continuing, getting off of investigation because you, or in spite of the let me put it another way. Have you ever had an experience in which an investigation continues to try to help somebody who won't cooperate with you?
No, sir. If someone won't cooperate, that's a giant stop sign.
All right. Now, if I want, after the 16th, in your conversation with the Attorney General, when was the next time you had any involvement in this case?
The next time was on the 23rd.
23rd of September?
Actually, let me back up. I had the meeting with the Attorney General on the 16th. One other significant matter occurred on this case that day that related to me, and that was in my email. I received a DocuSign email requesting approval or declination for an executive approval memorandum for an outside counsel contract for Brandon Kamek.
All right, can Your Honor, at this time, I'll move to introduce Exhibit 236. I believe it is not in evidence.
It is not.
I show it's not. I'm going to check with the true person.
Thank you, ma'am.
Can I have one? No.
Any objection?
Briefly, if I may, Your Honor, this document isn't a complete, if Your Honor will take a look at House Managers 236, it is a partial image of a DocuSign report, or what I'll call a completion report, but it doesn't go to the bottom and include Mark Penley.
Your Honor, if I may, this is the cover page, or one of the pages that will reflect what was happening with the document. It's already, there is a draft of it in evidence. I'll get that. If they object to this, then
It's just simply incomplete. We can't see what Mark Penley did and the dates at the bottom of 236.
that's fine. In the interest of time, I'll be glad to
Sustained.
do. Thank you. Now, in the conversation that you had with him on the 16th, the other matter you said that you didn't complete was what?
The other matter on the 16th was I received the DocuSign email.
Right. And what was the significance of you receiving that?
The significance was it was office practice for certain contracts to be approved by a number of people in the chain of command. And since this matter involved a criminal investigation, it was routed through me, and it was to go on to other people. The last signer was to be Jeff Mateer, the first assistant.
Did you sign off and agree to this contract for Mr. Kamek?
I did not.
And on the 16th of September, did you do anything in relation to it?
No, I saw it was there. I knew I wasn't going to approve it. I didn't touch it.
And if you didn't touch it, does anything happen with the contract until you, the division involved, sign off on it?
It should not have.
All right. And then when's the next time you had any contact with anyone about it?
The next time I had any news about the Nate Paul matter was on the 23rd.
And what happened on the 23rd, and what was your contact and with whom?
I had contact with Ryan Vassar. I got word that the Attorney General was asking where
Section hearsay?
It is. You're absolutely right.
Sustained.
You're absolutely right.
Thank you, Counselor, for that help.
Thank you. Thank you, Your Honor. So did you get talk at all to the Attorney General during this time frame?
Not between the 16th and 23rd, but I did on the 24th.
All right. On the 24th, where did you talk to him?
He called me on the phone. He told me he was at the White House. He said he just left a meeting in the Oval Office, and he wanted me to approve the DocuSign executive approval memo for the outside counsel contract.
What do you remember about that conversation?
I remember we talked for about 10 minutes, and that was the day that I drew the line with the Attorney General that I would not cross, and I never did. I said I would not approve the contract. I said,
hold on.
Object, non-responsive, move to strike.
Sustained.
Hold on. Just as best you can remember, tell us exactly what and how he said what he did, and then tell me your response to it.
He said, Mark, I'm at the White House. I just left a meeting in the Oval Office. I understand that the executive approval memo is with you. I need you to approve that contract.
At that time, were you aware one way or the other whether the contract had been signed by the Attorney General?
No, I wouldn't expect.
Yes, there you go. Did you know?
I didn't know.
All right. And so at that time, what was your level of knowledge of the status of the contract?
That it was stuck in my email inbox and it had not been approved through the normal office procedure because I wouldn't approve it.
All right. What did you respond to the Attorney General?
I said, Ken, I cannot approve this, and respectfully, I will not. And I told him why.
All right. Would you articulate for the jury exactly what you told him as to why you were not willing to approve that contract?
I told him that Nate Paul and his attorney were not being cooperative with us by giving us all the documents that I believe they had. They had gone to the media. Furthermore, there was no evidence of any crime. We had absolutely no scintilla of evidence that any criminal activity had occurred on the part of the federal agents, the state agents, the federal prosecutor, or the federal judge. And I said, ethically, Ken, I can't proceed with this investigation, and I'm the senior prosecutor in the agency. And if it's not right for me to do it, it's not right for me to delegate it to anybody else. I won't sign this.
What was his response?
He said, well, we'll have to disagree on this. I've got to go to a press conference. We'll talk later.
What was your history with the Attorney General as to how he would handle or respond to areas of disagreement with you and the staff?
Well, by this time, I'd realized he was very passive-aggressive.
And what do you mean?
I mean, he'd say something was okay or indicate he accepted your opinion one day, and then you'd find out later he had gone around you or he was disagreeing with you. But he wouldn't come and tell me that.
So over the months that this had been going on, had you become aware of anything involving Mr. Paul and the Attorney General? And this is as I'm really at the day of the 24th of September. Had you at that stage become aware of other incidents that were occurring, or were you pretty much just knowledgeable about the events that were affecting you?
I had heard a little bit about...
I don't want to hear what you heard,
Okay.
only that have you had heard things.
Yes, I'd heard some things, not much.
But as a practical matter, day by day, was your knowledge of things with the Attorney General and Mr. Paul pretty much generally restricted to the things that you've been telling the jury about that involved you?
Yes, my knowledge was siloed.
All right.
I didn't know about these other issues until later.
All right. Now, on the 24th, when you told him that, and he said, we'll just have to disagree.
Yes.
When was the next time you heard from him?
He called me again on the next day, Friday, September 25th.
And do you know where he was at that time?
I don't know.
And what did he say then?
He said, are you available to meet with me tomorrow?
What did you tell him?
I said, yes.
What happened? So what happened?
I said, can I assume it's about the matter we discussed yesterday? And he said it was. And then we talked about scheduling.
Where did he want to meet and when?
He wanted me to come to McKinney. I told him I had an event to go to in Denton in the middle of the day. I said, I'll meet you before or after. He asked me to meet with him at 2 o'clock in McKinney. He said he would text me a location, which he did later that day.
All right. So then, did you meet with the Attorney General of the state of Texas regarding Nate Paul and the contract for an outside lawyer to investigate? Did you meet with him about that matter on Saturday, September the 26th?
Yes, sir.
What time of day and where did you meet?
The meeting was scheduled to begin at 2 o'clock. I was there before 2. He arrived about 2:20 or 2:15. We met for an hour and 45 minutes.
And when he got there, where did you go? Where did you meet?
Well, he asked me to meet in one coffee shop, a Panera Bread, and I was there. He came inside and let's go sit outside. And he crossed the driveway. There was a Dunkin' Donuts across the driveway that had an outside table with an umbrella, and he wanted to sit there.
So unlike what we're experiencing so far right now in September, was it a September day with more normal weather that was cool enough to comfortably sit outside?
Yes, sir.
All right. And then who began the conversation?
He did.
What did he say?
He said he was frustrated. He said, I felt like I did when I couldn't get Chip Roy to do what I wanted him to do. My staff's not doing what I'm telling them.
Chip Roy was the previous first assistant, is that correct?
That's correct.
All right. Now, what did you respond to that?
Well, he then went on to talk about he wanted me to approve the contract. He was upset that I hadn't approved it or that Jeff Mateer hadn't approved it.
I want to go back, if I can, to whether or not you did any preparation for this meeting.
Yes, sir, I did.
Tell the jury what you did in anticipation of this meeting.
Well, in all honesty, I woke up at 5 o'clock in the morning, and I felt like the Lord woke me up and impressed upon me that I needed to get ready. This was a serious situation. Again, I felt like my job was in jeopardy. I didn't want to get fired, and I was hoping that I could get Ken Paxton to listen to reason. And so I did my morning Bible reading. There was a verse in there. It said, do true justice, Zechariah 7:9. And I wrote that on the top of my notes, and then I proceeded to write out a bullet point outline with all the problems with proceeding with the investigation of the Nate Paul matter. And I wrote down things that I felt like he needed to understand that were a danger to him personally and career-wise.
So if I may, I'm going to ask if we can show him a copy of the first page, of the notes that he prepared before the meeting. I have marked this as Exhibit 214. It's not in evidence, but I wonder if we have a copy we can show him that's clean. Mine's got all kind of markings on it.
Sir, I have a copy here.
Pardon me?
I have a copy.
I know, but I want to show you one that's got the exhibit.
Thank you.
I want you to look at it, identify it, but I don't want you to testify about what's in it yet. I want you to look and see if that is a true and accurate copy of the notes you prepared in anticipation of meeting with the Attorney General.
Yes, sir.
All right. Would you look at, there's a 2-page notes? Well, it's 3 pages, really, isn't it?
It's front and back copies.
All right.
There are 3 pages.
All right. You went away from your microphone again.
I'm sorry, there are 3 pages.
I've done it much more times than you have. All right. And do those notes accurately reflect your thoughts that you were reducing to writing in anticipation of discussing this subject with the Attorney General?
Yes, sir.
Your Honor, I'll move to introduce. These been produced. Both sides have these. Actually, I would think we received these notes from the Attorney General's office in the production. Or actually, we got them from Mr. Penley, excuse me.
Any objection?
Yes, Mr. President. These, Mr. Hardin has not provided me a copy of the document, but I'm extensively familiar with it. It's hearsay. These were not notes from a meeting with the Attorney General. These were the out-of-court statements of Mr. Penley expressed in an outline prior to the meeting. And hence they are inadmissible hearsay.
Okay, do we have a copy for the attorney, for the court?
Thank you very much, ma'am.
Does the court have a copy? Oh, thank you.
I'm going to sustain the objection.
Thank you. Now, these notes that you have, are these copy of these same notes that we've talked about, Exhibit 214. Do you have them up there with you?
I do.
Can you tell the jury in general, Sept, from your own memory, all the things that you planned you were going to tell him?
Yes.
Hold on. I believe that Your Honor sustained my objection to hearsay, and so any testimony from this document would also be fruit of that hearsay.
I didn't ask him to testify from it. In fact, I asked him the exact opposite. I said, simply put them down. Now tell us in your own mind. And if you need to refer to them to remind yourself of something, but my questions to you are directed to what you planned to tell the Attorney General.
Right.
In both tone and content for this meeting of the 26th.
Overruled. Continue. Continue.
Sir, what I planned to tell the Attorney General was, number one, this was a very dangerous investigation for him to continue. He was a friend of Nate Paul's. Nate Paul was a campaign donor to him. There was no evidence of any criminal wrongdoing. There was no legal basis to continue the investigation. There was no ethical basis to continue the investigation. In fact, I felt it was unethical to continue. I felt that Nate Paul was trying to manipulate me and Director Maxwell and the Attorney General to do an investigation that had no merit, and we shouldn't be doing it. And then I also told him there was great risk to him. This could look like bribery. This could turn into a criminal charge against him. I told him this could turn into a media scandal if it got out. I said, you should not be doing this. Please back away from this. Let me handle this my way. And then I had a section where I wanted to go over with him the practical difficulties of doing the investigation that he wanted us to do. As I explained previously, the issued set of search warrants were still under seal at the federal district clerk's office by federal court order. I had no way to get access to those. The original computer that the forensic experts
Mr. President, I need to object to the narrative testimony. This needs to be responsive to
Sustained.
question.
All right, so you're telling us what you plan to do. My next question is, did you tell him what you have just testified to the jury?
Yes, I told him all of those things and many others.
And I'm about to ask you about the many others. So let's go now to the 26th itself. You get up in the morning, you write all these things out that you've been testifying about. What else did you tell him in an attempt to persuade him to drop the Nate Paul matter?
Number one, I told him, I don't know Mr. Kamek. I don't know his experience level. It's my understanding he's never been a prosecutor. I'm not going to supervise him. He told me at that meeting for the first time that Mr. Kamek had already been hired and was working and had been working on this for at least 2 weeks. I did not know that.
What did you say in response to that?
Well, I said, I won't supervise him. And he said, don't worry, I will.
Well, did you know anything in the background of the Attorney General that would have qualified him to supervise a federal, or not a federal, but a state prosecution investigation?
Nothing whatsoever.
So when you said you wouldn't supervise him, and he said, don't worry, I will, what did he say then?
Well, I think the conversation shifted at that point, and I was trying to tell him, stop Mr. Kamek. In fact, this was at the end of the meeting. I had 2 recommendations for him. Stop Mr. Kamek and talk to Jeff Mateer about a way to get Mr. Kamek paid for whatever he's already done. That was one of the Attorney General's big issues in the conversation. This guy's working and I've got to pay him, and you won't sign the executive approval memo, so I don't have money in the budget to pay him with. And then he threw out, I spent $50,000 on my personal lawsuit last month. And then he made comments about his distrust of law enforcement and his concern about...
What did he say about law enforcement?
He said, you don't know what it feels like to be the target of a corrupt law enforcement investigation. I've spent $50,000 on my case, things of that nature. He made many comments to me, or several, I'll say several, during the course of these months that indicated he had a negative attitude and a distrust of law enforcement.
Did he particularly ever focus on DPS in his negative attitude?
Yes, I've heard him make negative comments about DPS.
Like what?
He doesn't trust the director, and he feels like the DPS ran a corrupt investigation on him in the securities fraud matter.
Did he have the same feeling about the securities board?
I did not hear him talk about the securities board.
All right. Were you aware one way or the other as to whether a representative of the securities board had been involved in a search warrant?
Yes, I knew at least one of their agents was a task force officer with the FBI on the searches.
And do you know who that officer was?
Yes.
Who?
His name is Rani Saban or Saban.
Will you spell Saban or Saban for the court reporter?
S-A-B-B-A-N.
How would he know? Do you know who? Let me back up. In your meetings with him, back starting in July and into August, in one of those meetings, was there a conversation with him and these are the 3 meetings we talked about.
Yes, sir.
In which he specifically addressed the issue as to whether Agent Saban was actually the applicant for the search warrant?
Objection, leading.
Did you ever hear?
Sustained.
Did you ever hear anything from him during those meetings with you about Agent Saban?
Yes, sir. You talking about Nate Paul's comments?
Yes.
Yes, I did.
And in the meetings, did you ever hear him say that Agent Saban was the affiant in the application for the search warrant?
Objection, hearsay, as I understand this to be Mr. Paul's comments offer for their truth.
Sustained.
Did you discover at any time that Mr. Wynn and Mr. Paul knew the identity of the agent that signed the application for the search warrant?
Objection, hearsay. If necessary, I will take this witness on voir dire to establish that the basis for his knowledge is hearsay.
Sustained.
Did you ultimately discover that these folks in your meetings knew who had been the applicant in a search warrant that was sealed, application that was sealed?
Same objection, hearsay. And I'm happy to take this witness on
I
board
asked
in
if-
order to establish that.
I asked if he ever became aware.
It's sustained.
All right. Now, would anyone be able to know the identity of the agent that signed the search warrant, the application for the search warrant, if they had not had access to a sealed document?
Objection assumes facts not in evidence and calls for this witness to speculate on that topic.
Let me ask you this. Did you review the grand jury subpoenas that were ultimately served by Mr. Kamat?
Yes.
Did you see the name of Agent Sabat on there?
Yes.
Would Agent Sabat's identity be known to anybody that had not seen the sealed document?
Objection calls for speculation
To
again.
your knowledge.
Sustained.
Now, do you remember back when the presentations, we make it a PowerPoint presentation they brought to that meeting?
Yes.
And do you recall what that PowerPoint presentation was called?
Yes, sir, I do. It was called Operation Longhorn.
Was that PowerPoint presented to you by Mr. Wynn and Mr. Paul?
Yes, Mr. Paul specifically.
All right. Can I have the exhibit number, please, of the PowerPoint? It's in evidence. In fact, I think it was introduced by the other side. Oh, that's okay. I think she's bringing it up.
It's in evidence.
Could you put up exhibit 152, please? Now, go to the next page, please. Do you recognize this exhibit, please?
I do. That's the document Mr. Paul gave me at the August 5th meeting.
Fine.
One moment, please. Can you confirm, Mr. Hardin, that everything has been redacted from this was the
Thank you very much. No, thank
piece
you
of
very much.
evidence that we paused to redact information?
I
Will
want
you
to make
confirm that?
sure.
I saw 2 thumbs up from Stacy.
Two thumbs up says it has been, Judge. And we've done that in light of the presentation. Thank you very much. In this search warrant, if we could, search warrant discussion rather, it talks about when it was executed, right? And it says down at the bottom, I'll read it to you. According to the filings with the court in the Western District of Texas, each of these warrants was signed and issued by Judge Mark Lane at 10 a.m. Is Judge Mark Lane one of the officials they wanted investigated?
Yes, he's a federal magistrate judge in Austin, and they wanted me to do a criminal investigation on him.
All right. Next page, please. Now, this sets out, does it not, that they have discovered through a forensic analysis of the metadata and what we've been talking about before. And it was emailed and given them by Alan Bew to the council's Chuck Meadows and Ayer Board. Those people were back in August 14th of 19 were representing Nate Paul, correct?
Yes, my understanding was at that time he was represented by Austin attorney Jerry Morris and the Dallas law firm of Meadows and Collier.
Next. Next page. Now, they point out to you that below is pertinent to how we discovered through forensic analysis in the document that had been mailed by the federal prosecutor. Alan Bew is the federal prosecutor, right?
Yes, he is.
Okay. Then they give us the data that they've got there as to where this server is located. Can I have the next page, please? They have the addresses where the search warrant was to be executed on, right?
Yes.
Next page. Now, do you have any idea how they would have all this information? Now, answer yes or no first.
Objection calls for speculation.
Do I have any idea?
Hold on, Mr.
The question was knowledge. I just have to add any knowledge of it.
If you can, answer yes or no.
Yes, I have some knowledge.
Can I have it talks, does it not, about Mr. Saban, does it not?
It does. It mentions his name at the top.
All right. Do you know if he appears in any of the document of the original search warrant itself? Have you looked at that to see of the part that was public, if his name appears at all?
Objection, lack of foundation for this witness's personal knowledge of that.
I asked if he has read the search warrant.
Sustained.
That was public. Let me try again, Your Honor. Have you looked at and reviewed the search warrant that was public information, is and was the search warrant that was ultimately given to the attorneys of Mr. Paul after the search?
Yes, sir.
On anywhere on that search warrant, does it mention the name of Mr. Saban?
No, sir, it does not.
Next page. It lays out, does it not, the things that they're complaining about, right?
It does, and
we-
these were things we told them we had no jurisdiction over.
Next page. Now it has people of interest. And are these people that they wanted you to investigate?
Yes, they wanted us to investigate each of these people.
Would you go down the list and see why, and tell us what they told you, or what these people they were requesting to be investigators' roles were?
Yes. Randy Saban was on the task force. He was at the search warrant that was executed at Mr. Paul's residence. Mr. Paul stated he had personal conversations with him during that search. Agent Joy of the FBI, he was mentioned. I don't know which location he searched. They represented that Ms. Sobravia Dent was a courtroom deputy clerk to a United States magistrate judge.
Yeah, can you explain to us why in the world you were supposed to investigate a courtroom deputy clerk of a federal magistrate?
I have no idea how there's a state interest in doing that. The federal authorities have full control over the federal district clerk's office, and their law enforcement and their inspector general's office has the full ability to go in and get all the documents needed to do such an investigation. We did not.
All right. Now, if I have the next page real quickly, and let's move through this. They give you information. This man that they want you to investigate was actually a member of the board of the agency that had brought the charges against the Attorney General, correct?
Yes, I became aware of that.
All right, that's it. That's all I need there. Did it have personal data about him that has been extracted from this?
Could I see that page again?
Yes. No, yeah, the page. If you know. If you don't know, doesn't matter.
And I'm sorry, could you
All
ask
right,
the question again?
Let's move on. You can take that down, but there were code words in this thing, weren't there?
Yes, there were.
Well, did you have any idea what they were or what they were supposed to represent? in
Oh,
this
Operation Longhorn?
Hold on. We're on top of
Excuse
each
me,
other.
try not to talk over each other for the court reporters.
Yeah, absolutely. Thank you, Judge. Your Honor. Were there different little code names like Longhorn and other things? You remember what any of them were?
Well, the only one I knew at the time was Operation Longhorn. I've learned some since this summer.
All right. Now, if I can, at the end of the day, on the 26th, when you were talking to him that Saturday, you've talked about almost 2-hour conversation.
Yes.
Do you recall at the end of the conversation, do you recall anything else that the Attorney General said to you in response to your urgings that you've described to the jury?
May I review my handwritten notes to refresh my recollection, because there were many other things discussed?
Yes, don't read from the notes, but you can look at them and see if that refreshes you.
All right.
To be clear, Mr. President, I do not know what notes he possesses up at the stand, and I would like to at least be able to review those.
I thought we gave him 214. If we did not, could we please?
214 are not notes, Mr. Hardin. That is his outline from before the meeting. So if he's using that to refresh his recollection, he will be using a document that has been overruled as hearsay.
Which, in more years than I'd like to admit, a witness regularly does. So that is not
An expert witness.
Excuse me, that's not a legitimate evidence. This man has brought up his notes. They're not in evidence. They've objected to him. He is certainly allowed to look at documents not in evidence to refresh his memory. He just can't read from them.
Would you show counsel these notes?
And Mr. President, what I would like to do is take this witness on voir dire to establish that, wait, hold on a second. You said 214, this is 216. So you're asking him to review 216? These are his notes, 216 is.
Pardon me?
Okay.
I've got a bunch of voices around
Got a lot of
here.
people
I'm
talking
sorry.
to you.
Go
Are you
ahead.
asking him to review 216?
You're right. You're right.
These are his notes.
Excuse me, just so the court knows what we're talking about. 214 is the document that he planned, of what he planned to talk about. He's right. 216 is what I'm asking him to look at and what he was about to look at. So I just gave you the wrong number. If you want 216, well, if you have 216s produced, do you have
No objection
216?
to 216. I plan to introduce it as well.
All right, neither one of them to answer your question earlier.
Have we settled this, counselors? No objection
I believe we have.
to what he's going to read from? Okay.
All right. Now, if you reviewed your notes from the day after, did you type up those notes, write those things by hand before or after, during, when did you do it, the meeting?
I wrote these notes when I got home that evening after the McKinney meeting, and they're handwritten.
Have you reviewed them?
No, sir, if I could have a minute, I wanted to be sure I had permission
Go ahead.
to. Yes, sir, I've reviewed the notes.
All right. Was there anything else you called? Does that help refresh your memory as to whether there was anything else in your discussion that the Attorney General said?
Yes, there were several things. Number one, I asked him why he was so interested in this investigation when he was not interested in all the other criminal investigations and cases we had pending in the office.
All right. And what was his response?
His response was, I don't know about the other cases, but I know about this one, and I'm concerned about corrupt law enforcement because of what's happened to me.
All right. Anything else you recall he said in that conversation on the 26th?
We discussed the fact that he had taken Nate Paul personally to the Travis County District Attorney's office.
Did you ask him or did he volunteer that?
I told him I had learned that. By this time, I had heard that.
And what was his response?
His response is, well, I didn't request the investigation from them. They had a conflict and they asked me if I wanted it, and I said yes.
All right. What else?
I told him there was no state basis for believing there was any state offense, and he kept bringing up Nate Paul and Michael Wynn's complaint that the agents hadn't left us a copy of the search warrant at the residence or the office, allegedly. I don't know if that's true or not.
Is that something he wanted the Attorney General's office to investigate about?
Apparently he did, because he told me that the fact that I didn't think that was serious, which I didn't, and I explained to him why. That's a federal rule of criminal procedure. That's not even a misdemeanor statute. And that's something the magistrate can deal with very easily if it's true. But he said that was a red flag to him that indicated I was too biased in favor of law enforcement.
How was the tone of this conversation?
He was frustrated, and that was the most, it wasn't a hostile conversation, but it was a difficult conversation.
How did the conversation end?
I told him that I was trying to be a loyal subordinate and a friend, and I still considered myself a friend even up to that very day. And I was trying to walk him back from what I thought was a dangerous line he was trying to cross. And I told him all my reasons, that he could face criminal charges, bribery, other things. It could be a media scandal. He could get himself in a lot of trouble. He needed to leave this alone, to back away from it. I explained all the practical investigation difficulties, that we shouldn't be trying to investigate the feds, and there were many things we couldn't investigate. We didn't have the power. We didn't have a way to get at those sealed search warrants. And if I'd called the U.S. Attorney's Office and said, "Can I see your file with the original search warrants?" they'd have laughed and hung up the phone, and I would have understood why. All that was under privilege at the U.S. Attorney's Office. They had an active investigation of Mr. Paul.
So how did when the conversation was over, what was said between the two of you as you parted?
The way I left it was I made two recommendations, which he didn't object to and he didn't disagree with, but then I found out later he obviously didn't act on them. Number one, I said, stop Kamek from working and talk to Jeff Mateer and figure out how to pay his invoice and don't let him work anymore. Number two, let's you and I meet with Jeff Mateer. I can explain some options we've got. I don't think they're great options. You may want to pursue them, but I think they're a risk to the office. One of those options was calling the United States Attorney's Office, talking to one of the supervisors, see if they would just assuage our curiosity and tell us if there were any changes between the return version of the search warrant and the issued version.
And what did he say?
He didn't say anything to that. He just said, well, I've got to go. I've got a dinner to attend. But he didn't agree or disagree.
After that conversation on the 26th, without going into what you said, did you call Jeff Mateer and update him?
Yes, immediately after I left the meeting.
And then after the 26th, when was your next involvement with anything having to do with Mr. Paul?
That was on the morning of Tuesday, September 29th.
And without going into what people told you at this time, what happened on the 29th?
Mr. Kamek and Mr. Wynn served a search warrant in the name of Brandon Kamek, Special Prosecutor, Office of the Attorney General of Texas, on Independent Bank in Round Rock.
What was your reaction to that?
I was apoplectic.
Why?
Because it appeared to me that Mr. Kamek was working on behalf of Nate Paul's civil litigation interests and serving a criminal process, a grand jury subpoena, on either a bank or a party to one of his civil lawsuits. He was seeking discovery through using criminal process.
Had the Attorney General ever said anything to you in his conversations that Mr. Kamek was a special prosecutor?
No, at this point in time, the only thing he'd ever told me was that he was working and beginning to gather information. He never told me a title.
All right. What happened on the 29th when you found out that their community bank had been served a grand jury subpoena?
Well, Jeff Mateer called a meeting in his office at 3 o'clock for the deputies involved that became the whistleblowers.
At the end of those conversations, did y'all make plans to go to the government?
No, not that day.
All right. And then what happened on the 30th?
On the 30th, in the morning, we got another message that a second subpoena had been served, this time on Amplify Credit Union in Austin.
And what was your reaction to that?
I was even more apoplectic. I was furious that this was going on and the Attorney General was allowing it.
And what was wrong with serving a grand jury subpoena on Amplify Credit Union?
Because again, this looked like Nate Paul was using the power and authority granted by the people of Texas and this legislature He had turned it over to Nate Paul for Nate Paul to go after
Object to
his
the narrative.
business opponents.
I asked you what was his objection
Sustained.
to it. Did you have, I believe, let me ask you this. When you were so concerned, what was wrong, in a very succinct way, please, what was wrong with what they were doing?
Number one, these banks had nothing to do with referral number one, which was the only referral we knew about. Number two, you can't use criminal process to conduct civil discovery, and that's what it appeared was going on, because Mr. Paul's attorney was with Mr. Kamek at both banks.
In all your years, first of all, have you been involved where the prosecutor was the one serving the grand jury subpoena?
No, sir, I haven't heard of that.
Who is usually the one serving grand jury subpoenas?
A deputy, a federal marshal, depending.
And then, have you ever heard of the lawyer for the person bringing the complaint, who's also under a federal investigation, accompanying the prosecutor serving the subpoena?
No, in fact, the Code of Criminal Procedure doesn't
Not
allow that.
responsive.
I'll get to that.
Sustained.
What is the law in terms as to whether or not a person representing the complainant can be involved in that circumstance?
The law says you can't. An interested party cannot be involved in serving a grand jury subpoena.
Now, after this, on the 30th, did you, as a group, ultimately go to the FBI?
Yes, after we learned about the second grand jury subpoena being served, we were extremely concerned as a group. I was extremely concerned personally, and we decided we had to go to law enforcement.
And why did you go to law enforcement?
Because this had to be stopped. The Attorney General obviously wasn't listening to anybody. He had turned Mr. Kamek loose. We didn't know what Mr. Kamek was going to do. It appeared that Mr. Paul was controlling this
Object
because
to the narrative and speculation.
I asked him why he went, what was in his mind. Let me ask you this. What did you expect the consequences being of your going to the FBI?
I feared we would get fired.
And was that the sense and mood of the whole group?
I think so. I think we all knew this was an incredibly dangerous and unique but outrageous situation. We were the only ones that could stop it, and we had to.
When you went to the FBI, did you take any documents?
Did not take any documents.
Would the documents all been the property of the AG's office?
Yes.
So is that why you didn't take any documents? Just yes or
Objection
no?
leading.
Why did you not take any
Sustained.
documents? Excuse me, why did you not take any documents?
I didn't take any because I felt like we were making the initial report based on our eyewitness personal knowledge of what we believed at that point to be criminal behavior by the Attorney General.
And so when you went, did you take evidence with you?
I took my personal knowledge and the others took theirs.
All right. Is that evidence?
Absolutely. We were eyewitnesses.
So if a person is the victim of an aggravated robbery and reports it to the police, would it quit being evidence if just they report it as opposed to taking documents?
Objection leading and relevance.
Their personal experience.
Hold on.
Yeah.
Sustained.
What did you take with you that would first of all of y'all going,
Yes.
did you take evidence in the meaning of evidence?
Yes.
What did you take with you that was evidence?
Our personal eyewitness knowledge, our personal experiences, our personal conversations with the Attorney General, our personal experience of him pressuring us to do things that were improper, unethical, and illegal.
In your experience, how often is the initial report by a citizen of something that they consider criminal conduct, how often is that where the witnesses come in without any documents just to tell you what they believe, they saw, they know that they think is improper? How often is that the way it gets to your desk?
Objection relevance.
Oh, it's very relevant.
Overruled.
Yeah, thank you.
That is very common.
So if a person walks in to report what they believe is a criminal offense or improper conduct that should be investigated, do you send them away if they don't have paper?
No, sir.
So what is your testimony as to whether or not, how much, from how many people, evidence was presented to the FBI with the request for them to investigate?
The meeting lasted almost 4 hours. It consisted of us sitting around a conference table with 2 FBI agents, and our attorney, Johnny Sutton, was present. The FBI agents asked us to go around the table in turn, starting with Jeff Mateer, and tell our entire story. And as I said, it took almost 4 hours. That was 4 hours of eyewitness personal knowledge from people directly involved with the Attorney General, the events I've described, and the events the others were involved in, the others being the whistleblowers.
Mr. Penley, after that meeting, did you yourself file any documents to attempt to or to quash the subpoenas that you had learned that had been filed?
Yes.
Yes or no? That's all I'm asking you.
Yes.
And why was it that you filed a motion to quash those subpoenas?
Because those subpoenas were improper and they had to be stopped.
All right. And what was improper about those subpoenas?
Number one, Brandon Kamek was not a special prosecutor, yet that's how he represented himself to the Travis County DA's office.
All right. Now, at the end of the day, after those subpoenas were quashed, what happened with you in terms of whether or not you went to the media or anything else? Did you?
I've never gone to the media other than I think our attorneys filed, may have written in an editorial sometime earlier this year.
Was at that time, what was the Attorney General's response in the media that you folks felt obligated to respond to?
The following week, the week of October the 5th, the Attorney General's office issued 2 press releases that made negative comments about the group of whistleblowers, claiming that we had impeded an investigation, claimed that we were rogue employees, and later the Attorney General claimed we'd even committed crimes.
What was your group's response to that?
Well, everybody was outraged.
All right. Let me ask you this. Are you one of the plaintiffs in the whistleblower lawsuit?
Yes, sir. I'm one of 4 plaintiffs.
Why did you decide to sue?
I sued because I was damaged by the office's actions in violation of the whistleblower statute.
And what financial impact did this all have on you?
Well, that had a big impact. After, number one, I was put on investigative leave on October the 2nd by order of the Attorney General. On November 2nd, a month later, I was fired illegally under the Whistleblower Act. I was given ridiculous reasons for the firing.
What were the reasons you were given?
The reasons I recall, and these came from the new first assistant who got rid of all 8 of us within 45 days. He said I'd lost the Attorney General's trust. I violated.
Hearsay.
I asked for reasons he was given for firing.
Overruled.
He said I'd lost the Attorney General's trust, number one. Number two, he claimed I used an insubordinate tone when he demanded to have my cell phone handed over to him so he could examine it without a search warrant.
What is that? What is that about?
He claimed there were public information requests to the Office of the Attorney General, and he demanded to see my text messages.
All right. Now, did that all become part of litigation later?
That became part of the litigation. And then the third reason was...
What was the third?
Yeah, reason number three, he claimed that I had violated a direct instruction from the Attorney General when I filed the motion to quash and when I sent a cease and desist letter to Brandon Kamek, and that is untrue. He claimed that on September 16th, when the Attorney General asked me for information about the documents I wanted from Michael Wynn and Nate Paul, at the end of that meeting, the Attorney General said, "Don't do any more on this." The context was, don't ask.
That's okay. Hold on. Okay. I really, really want to finish up here with you to ask you this. After all you've been telling the jury about, after all you've been doing differently, would you do anything differently?
No, sir. I'd do the same thing all over again because it was the right thing to do and the only thing we could do, other than stand by silently and let crimes be committed. The agency was being abused. The laws were being abused. The behavior and the conduct of the Attorney General of Texas
Object
was
to the narrative.
outrageous.
Object to the narrative.
Sustained.
I'll pass.